Hi, my name is Jen Sandberg, and I'm an attorney here with the Vethin Law Firm in the Houston office, and this is my colleague Cameron Weir. And today we're on the lawn of the 1918 courthouse in downtown Houston. And today's video, a part of the VLF's continuing video education series, is on preparing for litigation and the litigation process.
So Jens, what's important here is when you or your company start to see a dispute happening that you can't resolve by communication, you need to start documenting your communication. Put it in writing, because once you get down to the courthouse, it doesn't matter what he said or she said, what matters is what you can prove. So start putting your communications with the person you're having a dispute with into emails, into texts, and that also not only documents what is said, but when it was said. And that's an important thing to have happen.
And then coming up with a timeline of events really helps us as attorneys kind of create a story and kind of create the first thing that we usually file, which is called the petition. And that's where you lay out the facts and you lay out the claims that you're making against the other person.
Okay, but then there's also what happens if you are the one being sued. Then what we are going to prepare on your behalf is an answer. An answer is due on the Monday morning, 10 a.m., after the expiration of 20 days. It is very important that you do not miss that deadline, because then, if you do, the other side can get a default judgment against you.
And so once the lawsuit is started, you go into what we call the discovery phase. And that's where each side gets to find out the facts regarding the claims and the dispute that has arisen. And there's different types of discovery. There's requests for production, where you produce documents. There's interrogatories, which are basically statements that you make on paper. There's requests for admissions, where the other side is going to ask you to admit to certain facts. And then there's the big one, the deposition.
Depositions are key because it is each side's chance to get the opposing side's testimony on record. And then they can hold them to that testimony later at trial, because depositions are taken under oath, meaning that you are swearing to the veracity of what you are saying in that deposition.
And a lot of those discovery tools are used to create what we call dispositive motions. And dispositive motions are basically, they get rid of claims or they prove their claims in their entirety at trial, where there's no facts in dispute and you can prove your claim at law. Now, if you can't do that during the pre-trial phase, there's always an opportunity to settle.
And that happens at mediation. In most state court disputes, mediation is required by the court. And at mediation, you are in control of how to settle the dispute and on what terms. Once you get past the mediation stage, if you still can't come to an agreement with the other side, then the case is in the hands of either the jury or the judge.
So if you or your business thinks it's going to be involved in litigation, whether as a plaintiff or as a defendant, you need to act now and start preparing for that process. And we can help you with that. So give us a call, because at the Vethin Law Firm, your problem is our business.